All right, let's jump right into this. What exactly counts as a digital violation of a protection order in Washington, D.C. today? And, more importantly, what are the strict legal consequences if you cross that line? Welcome to today's Explainer. Look, we are dealing with a completely transformed legal landscape in 2026. So I want to break down this law for you the exact same way an experienced attorney would explain it to a client sitting right across the desk. Because whether you're a petitioner who's worried about ongoing digital harassment or you're a respondent just trying to figure out exactly what conduct gets you in trouble, you need to understand that the digital age has made these boundaries invisible but totally permanent.
So here's the roadmap for our explainer today. We're going to cover 1. DC protection orders today, 2. Defining digital contact, 3. The consequences of a violation, 4. MPD digital enforcement tactics, and finally, number 5, your next legal steps.
Okay, Section 1, DC protection orders today.
So here is the crucial baseline you have to know. Under DC Code Section 16-1005, the courts interpret no contact to mean absolutely zero digital interaction. None. No matter how seemingly minor it is. You know, people often think of protection orders as just physical proximity, like you've got to stay 100 feet away from someone. Not anymore. A protection order commands a respondent to refrain from contacting the petitioner in any way. And in 2026, the courts are absolutely applying that mandate to the smartphones sitting right in our pockets.
Moving right along to Section 2, defining digital contact.
Now, there's a huge legal difference between direct messages and indirect contact. But let me be clear, both of them are absolute violations. Direct contact is obvious, right? Texts, emails, a quick FaceTime attempt, but indirect contact is where so many people trip up. Asking a mutual friend to relay a message, using what the courts literally call flying monkeys to harass someone on your behalf, that is a strict violation. Even posting a vague status update that only the petitioner would understand, often called vague booking, or commenting on a mutual friend's post just because you know they'll see it, yep, that crosses the legal line for sure.
What's wild here is how mundane these actions actually seem on the surface. We're talking about a single emoji or a phone call that goes unanswered. That is enough to trigger a violation. The actual content of your message? Completely irrelevant. You could send a neutral text about picking up some shared property or a simple happy birthday, and the court treats that exactly the same as a threat. Liking a photo, tagging them in a meme, calling and just letting it ring to voicemail, every single one of those actions shows an attempt to maintain a connection, and the court views every single one of them as a breach of the order.
Okay, I really need to bust a massive myth for you right now. If the protected party texts you first, you are still strictly prohibited from responding. I know, it sounds unfair, but this is a massive trap for respondents. Sometimes the petitioner might reach out on social media, maybe they attempt to reconcile, but because the order legally restricts the respondent, the petitioner legally cannot violate their own order. But if you reply, boom, you have violated the order, period. If they contact you, your only legal move is to not respond, document that contact, and call your attorney immediately.
And it goes further than just messaging. Passive surveillance or tracking someone's location digitally isn't just a violation of the protection order, it is potentially a totally separate stalking charge. Look, just viewing a public profile might not be illegal on its own, but in the context of a protection order, obsessive monitoring is absolutely viewed as harassment. And if you're using Find My iPhone, snooping through shared cloud accounts, or sticking an AirTag on their car, that is unauthorized surveillance, and I promise you it will trigger severe legal consequences.
Let's get into the hard numbers. Section 3, consequences of a violation.
The financial hit here is severe. We are talking about fines up to $1,000 per violation, and judges have full discretion to slap these fines on top of any other sanctions. Plus, they can order the respondent to pay the petitioner's attorney fees and foot the bill for the costs of documenting all those digital violations.
On top of the money, a violation is chargeable as criminal contempt, which carries up to 180 days in jail. This is a misdemeanor offense and is prosecuted by the D.C. Attorney General's office. Now sure, a first-time, relatively minor violation might just result in probation and mandatory counseling, but judges view digital violations extremely seriously. Why? Because sitting down and typing out a message shows premeditation. It's not just some heat-of-the-moment physical encounter. You had to think about it, type it, and send it.
And here is the real kicker, the compounding penalties. 10 separate text messages, that literally equals 10 separate contempt charges. The penalties escalate incredibly fast. If you send a rapid-fire string of angry texts, each and every one of those is an individual violation carrying its own potential jail time and fine.
A pattern of these violations can easily lead courts to convert a civil order into a criminal no-contact order or extend the protection order for up to 2 full years.
So, how do they actually catch this stuff? Section 4. MPD Digital Enforcement Tactics.
Well, the reality of modern enforcement is pretty ruthless. Think deleting a message protects you? Absolutely not. NPD forensics can and will recover it. The MPD Domestic Violence Unit uses highly specialized tools to pull deleted messages, build digital timelines, and even trace anonymous burner accounts back to the source. When officers arrive at a scene today, they aren't just asking about physical threats anymore. They are immediately photographing screens, collecting device metadata, and locking down digital evidence. And honestly, the illusion of digital anonymity is just completely gone. MPD and DC Superior Court maintain partnerships with major platforms like Meta, X, and TikTok for expedited data preservation requests. These companies literally have dedicated law enforcement portals now. So if a violation occurs, police can lock down those messages, the login locations, and the IP addresses in a matter of days, long before a respondent even gets the chance to wipe their account.
Courts are also leaning heavily into advanced tech to ensure strict compliance. For high-risk respondents, a judge can order a 24/7 GPS ankle monitor as a condition of release. Prosecutors even use specialized software to archive social media content in real time. And what if the parties share kids and literally have to communicate? The court won't let you just text each other. They'll mandate a monitored platform like our Family Wizard, where every single message is timestamped and physically cannot be deleted.
Which brings us to our final part. Section 5, your next legal steps. If you are the one seeking protection, you need to follow this exact checklist to document violations before they vanish. First, take screenshots, but make sure you capture the full context. We need usernames, timestamps, the whole shebang. Second, save the specific URLs of the posts. That helps investigators find cached versions later if they get taken down. Third, back all of this evidence up to a secure cloud or an external drive. Once you've got it secured, you or your attorney can file a motion for contempt with the DC Superior Court's Domestic Violence Division, or directly contact the MPD.
Now, regardless of which side of the desk you're sitting on today, immediate legal action is critical. If you're accused of a violation, do not delete anything. It looks exactly like evidence tampering. Do not respond to the petitioner, and call a lawyer right away. On the flip side, if you're seeking protection, lock down your privacy settings immediately. Revoke access to any shared cloud or smart home accounts, block the respondent entirely across the board, and work closely with DC advocates and law enforcement.
And look, if you want experienced, direct legal counsel regarding DC civil protection orders, you really need to visit LopezLawFirmDC.com. Attorney Carlos Lopez and his team have over 20 years of experience navigating the DC's Superior Court Family Division. They know exactly how to handle these complex digital forensics, how to subpoena platform records, and how to present compelling, bulletproof arguments to judges to ensure your rights and your safety are fully protected.
I'll leave you with this final thought. The digital trail you leave behind is permanent, so you have to ensure your legal strategy is built to handle it. The laws in Washington, D.C. have fully caught up to the technology sitting in our pockets. Please don't assume a simple emoji or an unanswered phone call is going to fly under the radar. Understand the rules, protect yourself, and get the right legal team on your side. Can you really afford to leave your defense to chance? That wraps up our explainer for today.